Hello, my name is Lauren Southern with the Rebel Media. A couple weeks ago, the verdict for the Gregory Alan Elliot trial was pushed back and a new verdict date has been set for January 22nd, 2016. The trial has already been going on for about 3 years now. If you don't know about this case, Gregory Alan Elliot has been charged for alleged criminal harassment by 3 social justice warriors simply for sending tweets at these girls opposing their plan to ruin the life of a young man who made a video game they didn't like. The case is a lot more complicated than this, so I suggest you click on the link below in the description, which has a longer interview with myself and Clayton Elliot, Gregory Alan Elliot's son, who I actually have here today to give me some updates on the case. So hi, Clayton. Thank you for doing this interview today.
Hey, Lauren. Thanks so much for doing the interview.
Definitely. So I know your father recently appeared for what was supposed to be his last day in court for the final verdict, but it was not. I'm curious if you could let us know exactly why the verdict date has been pushed back and how this might affect your father's case.
Yeah, no problem. So the final verdict date was originally supposed to be for October 6th of 2015, which was last week. The verdict date was pushed back essentially because an application for amendment was brought forward by the Crown prosecutor on August 6th. So to take back a little further, on July 14th, when we were in court doing the final submissions, the lawyers were doing their final oral submissions, a point was brought up about a discrepancy between the original charges my father was arraigned on, and the details in the lawyer's final submissions. So, without going into too much detail, essentially, I'm trying to sum it up. My dad was charged for knowingly harassing. That was the charge. He knew what he was doing, and and as a result of what he was doing, he harassed him, and he knew what he was doing was harassing. In the final submissions, I believe the Crown, in her closing submissions, the Crown submitted that my dad knew that the complaints were harassed or was reckless as to whether or not. So she kind of included that. Our lawyer responded in his response, mentioning as well the knowing, challenging the knowing element as well as the recklessness element.
So that was just added randomly, just at the end there, that he recklessly did it?
Well, like on the original charges that he got on November 21st and, later in January, the charges read that he knew what he was doing. He knowingly did, knowing that the accused are harassed, did repeatedly communicate, and so on and so on. But the terms are knowing. And criminal harassment, I'll get to the minute. I just want to give you kind of play-by-play of the time frame from, July 14th, we had court, it was done. The judge went into deliberation at that point, saying that he could figure out the discrepancy. On August 5th, we were called back into court by him, and he essentially put it to both lawyers and said, can I amend these points of consideration, the recklessness and the knowing, can I amend them without an injustice being done? And it had both lawyers agreed then and there on August 5th that, they could be amended without an injustice being done, then it would have been done. But our lawyer said no. He challenged and he said, this is, I don't agree to. And to be fair, he wasn't even present in the courtroom. He was on vacation with his family. He was called in by telephone. So he appeared in court that day by telephone. So he was at a disadvantage of not being able to see anything, not be able to see the judge or the Crown or even be there present. And at the end, I think, for whatever reasons he knows what's going on far better than I do. He said no. He said he doesn't agree to it. And from that point forward, the judge said, well, fine, then they will be kept separate unless the Crown submits an application for amendment. So on August 6th, the day after we were in court, she submitted her application for amendment to have the charges amended. Our lawyer responded in writing, and a new date was set, like an intermediary date was set for September 4th of 2015, with the October 6th date still standing as the final verdict date. So when we showed up on September 4th, the Crown had her whole argument for why it should be amended. She referenced some case law for past, trials and cases where charges were amended. The examples she used weren't directly like relatable to my dad's case, but those are the ones that's what she argued. Our lawyer didn't actually even prepare arguments back. In his written submissions, he requested that the judge not even accept the application, and he said that I'm not going to prepare written submissions. It takes time and energy and my client's money. I request that the judge just dismiss this application. So when we went September 4th into court, she argued her case. He gave our lawyer, he said, I know you haven't had time to prepare any response, but do you have anything you want to add, anything you want to say to this? And without having prepared, he kind of just, his understanding of law and his knowledge of law, he gave his points. And the judge said to him, okay, well, I'm going to need you to provide official submissions on this. I can't rule in favor of you against her when she argued her submissions and you didn't. Like, I need to hear from both sides to make a fair and accurate determination, a fair and accurate ruling, listening to both sides' arguments. So he's like, you got to come back in and argue it. So the October 6th date that was supposed to be the final verdict now became the new day for my dad's lawyer to come back in and argue it. He came in on October 6th, provided his verbal submissions. At the end of the day, the judge and the defense and the Crown all tried to figure out when the next available date was for all parties to be able to, show up to get the final verdict. The judge tried. He tried to get it as early as possible. He pushed to have it for beginning of December, early December. But I wasn't sure if our lawyer or the Crown, either way, they couldn't get all the dates to align. And the only date they were able to get that aligned for all three of them was January 22nd, 2016.
Okay. So I just want to go back to the application for amendment that you were talking about. So I've read the Crown prosecutor, Marnie Goldberg, is trying to change those details of the charge, as you said, from claiming your father knowingly harassed his alleged victims, to he knowingly harassed them, and if not, he recklessly harassed them. So could you explain how that change would affect the case, and just explain that for viewers at home in a little more detail?
Yeah, no problem. I'll do my best. I'm not a lawyer, and I don't speak legalese, but I can do my best based on what I've heard from our lawyer and what I've been able to research myself. So recklessness, there's a number of things that have to be present to establish recklessness. One of them being the mindset of the accused. So, similarly, I guess, in a murder case, there's a big difference between first degree, second degree, and manslaughter. The end result is still, someone was victimized and tragically lost their life, but it's a difference in sentencing. It's a very, very big difference in the state of mind. Is, did they know what they were doing? Were they aware of it? Did they plan it? Or were they completely ignorant, So knowingly, is he knew what he was doing. He was fully aware of what he was doing. And recklessness is my understanding is he recognized a risk, but he took it anyways. He recognized there was a risk and what he was doing could hurt someone, and he did it anyways. That's my understanding of recklessness. So these points of consideration, they determine mens rea, state of mind. It's the state of mind of the accused. So like I said before, the original charges he was charged on was that he knowingly harassed. During the course of the whole trial, I didn't hear any arguments for what he was doing was reckless. He was reckless, Maybe he didn't know what he was doing, but as a result, he still harassed. All I heard throughout the trial was he knew, he must have known, he knew he was blocked, he knew. And that was the line of argument that kind of was argued.
That's what was being argued for the 3 years of the case, right? And just last minute.
Well, yeah, like the trial started about a year and 4 months, about 16 months after the day he was arrested. That's when the trial started. But for the whole duration of the trial, it was he knew. That's what I remember hearing. And so the original charges that he knew. at the end of the day, they're different. So
Mm-hmm.
to prove recklessness and to prove knowing, there's different things for the judge to consider, and for him to consider it, it generally has to be argued by the Crown. Now, she said that she wouldn't have argued the case any differently. She argues that, she argued the whole case as if she was considering recklessness, and it was just like a clerical error on the arraigning documents, that is and why she's arguing for the amendment. Yeah, so essentially I don't want to say it changes the charge, because the charge is still criminal harassment, but it changes the specificity of the charge. It changes
It makes it more broad and probably easier to charge.
I'm not too sure. The judge was saying there's certain things, if she wants to prove reckless, there's certain things that have to be proven for the judge to determine that my father recklessly harassed. It's a different weighing of evidence. It's a different paths of logic and reasoning that he's going to go down to come to his conclusions. And as of right now, he's only considering knowing, because that was what my dad was charged on. So
would you say if this is changed, it would complicate, and that's kind of why it's been pushed back, because it's been complicated more?
Yeah, I would say in defense of him and everybody involved, like, I think the Crown's trying to win. She's doing everything she can to win. This application was brought forth in the latest possible stage in a trial. Like while the judge is already in deliberation. This is like after the judge in deliberation. There's no later stage she could have brought this application forward. And our lawyer was saying, he's like, I'm not gonna assist the Crown in her conviction of our client. Like, that's her job to establish the evidence and provide the evidence and get very clear on what they're charging him for. Like, what are they charging him for, and how are they then proving that? Because the proof is on her to prove beyond a reasonable doubt that my dad, is guilty of these accusations. So essentially, if they're brought together, if the judge on December 15th, I believe, the judge will have his verdict, his ruling on this application, and he'll either determine that it is fair and it is within law, within reasonable law to amend these charges, and then he'll consider both, or he'll determine that it's not, and then he'll keep them separate as well, and it will just be the knowing. He'll proceed to his final verdict, just considering knowing as the state of mind.
So that's
my best way to describe it all.
Yeah, no, for sure, I got that. The Crown bringing this up last minute is kind of strange, and there's been a lot of kind of weird suspect things going on with this case. In fact, Genuine Witty has published a chart showing the connections between politicians, media, police, and the alleged victims in this case. I would highly suggest people go and check that out on Genuine Witty's website. I'll also have that linked in the description below. But do you think you could give us just a little bit of background on why he made that chart for his website on these connections and why it's significant?
Yeah, for sure. So Greg Renault at Genuine Witty has been looking at this very closely since, I think, some of the very first days we've been in court. He's found things that we had no idea were even going on. And so he created this relationship chart, this connection chart, to show all the different connections with all the parties involved that aren't even named in this, that go beyond this. And I actually think most of them are actually named in the disclosure. But essentially, our lawyer's argument from the beginning was that, the complainants, along with a number of their friends, named and unnamed, months prior to my dad's arrest, sometime in July or August during the summer of 2012, got together and planned how to, quote unquote, deal with, Greg, how to, quote unquote, handle the situation. they claim that in their testimony that there was no plan. No plan was hatched. There was no actionable items that came out of these meetings. They just, met to discuss, and no one could remember exactly what was discussed at this meetings or what was the outcome.
Of course not.
Yeah, but then as we look deeper and deeper and deeper, we see all these different parties and different players and different individuals that, in a roundabout way, seem to be beneficiaries of this. They seem to be in a position where they can benefit in some way from my dad getting charged and convicted of this. And I don't want to speculate too much or dive too far down the rabbit hole without really hard evidence. But I think the relationship map, Genuine Witty will be continuing to update that and provide more information as he finds it. And it's creepy. It's kind of creepy. Like the implications of it and what it suggests and what it appears, to us is a real conspiracy to set him up. And it's, we'll have to see, down the road. There's still, time will only tell exactly what's going on. But if anybody who wants to do their own research, there's a lot of names there and connections that they can go and start digging into and figuring out. And hopefully Genuine Witty continues to provide more details on all the different names on that map.
Definitely. And yeah, please go check out Genuine Witty's blog. He's done excellent reporting on it. And also Christy Blatchford, all of her reporting for the National Post has been amazing on this. Just one last question here. How has the delay that has happened affected your dad's legal fees? Because I know you said he had already paid $50,000 and has another $30,000 to pay. Has that number increased because of this delay?
So as of July 14th, 2015, he had paid out of pocket roughly around $50,000 and owed another 30 or so. At that point, the lawyer was done working. He was not on the clock anymore. He was done, and it was just about squaring that up. When he got called back in August 4th for the phone call, I don't think he did any preparation for that, and he wasn't there physically. But after that, on September 4th, he had to physically show up. It's for a full day in court. It's definitely not cheap. I'm not sure exactly what that bill was. And then the October 6th date we had to show up for, he had to prepare all of his submissions for. So, I have no idea exactly how many hours he worked to do that. He provided some pretty thick booklets of information during October 6th. So I'm guessing on top of the $50,000 he's already spent, I'm guessing he owes another between $30,000 and $40,000, give or take, maybe a little more.
Wow. Yeah, no, and you guys have your IndieGoGo campaign up right now that I'd really suggest everyone watching goes to. They're trying to raise money to pay for these $80,000 plus some legal fees that they've racked up, simply trying to keep Gregory Alan Elliot out of jail for tweeting these girls. So please, please, please go check out your IndieGoGo campaign. We'll get that link in the description as well. And also just look into this case. Like we were saying earlier, there's been some creepy things going on, and your father has just had his life kind of torn apart by this for the past 3 years. And also, could you just give us an update on how your father is just taking this, how he's dealing with the delay in the case?
Yeah, it's like I'll be totally honest. It's hit him really hard. This whole thing, not even just the delay, the entire thing has been seriously damaged him. He's been out of work. He's been unemployed. He's lost his job. He's been hit, and he tries to stay optimistic. He tries to remain positive and upbeat about it. But this final extension of the finish line, essentially, another 4 months, really hit him hard. He said it feels like, because originally this was scheduled for 5 days in January of 2014. Like, no one could have predicted, not the judge, not the lawyer, not the Crown, no one could have predicted that it was going to take this much longer. Because I think with the evidence they had, they assumed 5 days. But as we started the trial and we started to do our research, we started providing more evidence. So the more evidence we provided that got submitted into the final compilation of evidence for, before the judge for him to consider, we contributed a lot of that. And then with every tweet we brought, with every piece of information we brought, we had to put to the complainants to eventually get it to be entered into evidence. So the 5 days plus another 5 days plus another 5 days plus another couple days here and there, he wasn't planning for this emotionally, financially, at all. And it just kept going on and on and on. By the time January 22nd comes around, it will be 3 years and 2 months from the day of his arrest, give or take. And yeah, he's not doing well. I'm with him on a daily basis. I spend a lot of time with him, and I'm no doctor. He hasn't officially been diagnosed with depression or PTSD or anything like that. But I wouldn't, I Googled the signs and symptoms of it, and he's definitely showing signs and symptoms. And he had a job before with a healthcare plan. At least then he had medical. He's not even able to see any professionals who can help him with what he's going through, because he definitely can use some help. So. I'm optimistic that, we'll get through this and we will find a way to get him back on his feet, standing firm again. But no, I've seen him in much better shape. And I haven't seen him in much worse shape than this. So.
And I know you guys have a hashtag going, because I just want people, because there's so many people that I talk to online that do support your father and do want him to get through this case and are genuinely concerned for you guys. You've had people donating to your campaign. Your hashtag is GAE, freedom of tweets, correct?
Yeah, hashtag freedom of tweets, GAE on the end.
Right. So if everyone could just tweet that and send Gregory Alan Elliot some love, that would be awesome. I know your father has been sending people love around his city with his, he makes the little hearts with the smiley faces on them and puts the stickers around your city to remind people just to be happy and smile, right?
Yeah, he says even loving kindness needs a reminder, and what's interesting is that some of these are popping up that he hasn't even put. So it seems other people are now copycatting him and putting them up all over the place. So like, he's put many up, but it seems now that many more people are putting many more up, which is really cool. He's very excited about that. And yeah, also the crowdfunding as well. I know some people were interested in PayPal and preferred to donate money through PayPal. If they go to just paypal.me, so not .com, paypal.me/Gregory Alan Elliot, GREGORYALANELLIOTT. They can donate straight to his PayPal wallet right there. So that's another option for those who don't want to use the IndieGoGo and credit cards in IndieGoGo.
I'll put that in the description as well. You know what we should do? We should also start, like how everyone does the rainbow flag on their Facebook and their Twitter profiles. We should start putting the little heart beside our profile photos. Do you have a like kind of outline for that? You could send me. I'll put it on my Twitter profile and post it so everyone else can do that.
I can send you a heart. That'd be cool.
Yeah, that'd be awesome if we got that going.
Yeah.
All right. So I just want to once again remind everyone who loves freedom of speech and stands up for it. This trial has been ridiculous. Please, please, please go and help out this family so that this doesn't set a precedent for free speech in Canada. Disagreeing with people on Twitter should not be something that gets you put in jail. So anyways, Clayton, do you have anything else to add before we finish up this interview?
No, I'm just very grateful for you, Lauren, for spreading this message, getting it out there. There's a lot of stuff that we have going on in our family. I wish I had more time to devote to this, and we just really appreciate you guys getting this out there and spreading this message. There's surprisingly a lot of people still don't know that this is even happening. And when I tell some people, they're like, "What? This is actually occurring?" Like, it blows their mind. Like, we still get people sending messages and emails just saying, "I just heard about this now. Like, I can't believe it. Please, like, stand strong. We have your back." So it's still getting out there. So I'm very grateful for you for, leading the initiative to get this out there. And hopefully these next 3 months just fly by really quickly. And, we're praying and hoping for a positive verdict for my dad. And then, his life starts patching it back together as of January 23rd. So
definitely. Yeah, thank you for coming on. I obviously want to help you guys out. This is an extremely important case. And once again, like you were saying, this needs to be shared. This needs to be shared on people's Twitter, their Facebook, the IndieGoGo campaign, these videos. We need to get the word out. So everyone watching, please, please, please share this so we can get the word out there. Anyways.
And you know, I want to add one more point, and I said this in the last one, and I'd like anybody watching this video to know that this is the position of my dad. I'm speaking on behalf of him. These are his words, and my words as well. Like, we need to spread the word about this. People need to know that this is happening. But what we don't need, what he doesn't need, it doesn't serve his cause. It doesn't help his campaign. It doesn't help his case. It does not help him when people attack the complainants, when people send hateful messages, when people are threatening them, things like that. It just adds fuel to whatever fire they have. And if you want to support my dad, promote his campaign, promote IndieGoGo, donate to IndieGoGo, use the hashtag, do anything else other than send hateful information. I'm not saying, you know, I haven't seen any of the messages, but supposedly that every time after the final day in court, you know, Christy Blatcher wrote this article, then all these people started supposedly, you know, sending them all this hateful stuff, and they, you know, it's just it's escalation. It's more escalation, and like, you know, we would like to call for like cooler minds to look at this and examine this without getting too angry. And it's easy to get angry at these kind of stuff, but you know, channel it in a way that is not going to give any more fuel to their stance. You know what I mean? Because every time somebody says a hateful message to them, it says, hey, look, you know, they're rallying hate against us. We don't want anybody doing this. If you're doing this, you're not doing it on our behalf. So please, intellectually debate, challenge, share the information, look at all the information, read the court transcripts, share it, you know, discuss it. But, you know, no directful, hateful, violent language, please.
Yes, let's make this a campaign of love for your father as he would want it to be, with smiley face, hearts, and donations.
Yes,
not
exactly.
messages.
That's what he would want, yes.
Of course. All right, so thank you so much for the interview, Clayton. All the links will be in the description below. For those of you who want to check them out, please share the video and the links below. And thank you for watching. I'm Lauren Southern with Rebel Media.